Today's date is April 12th, 2020, approximately 13:02 hours. It's Capt. Roman here with Officer Myers and FOP Representative Ross Faree. Reference IA 22-02. Officer Myers will hand you a copy of administrative proceedings, also investigator rights. We're going to review those, and if you understand, go ahead and sign, date, and time them, please. Okay. The record also has assigned administrative proceedings rights, and Representative Faree is also signing, acknowledging. Okay. All right. Again, I'll just direct your attention to March 15th, approximately 17:12 hours. You stopped a GMC pickup truck. During this traffic stop, you eventually identified the driver as Sidney Hurton. Is that correct?
It is.
Do you recall what you stopped Mr. Hurton for?
It was a speeding violation.
Okay. Did Mr. Hurton exhibit any unusual behaviors or acts?
A number of them. Want me to go through the whole?
Sure.
Okay. So, from the very onset, the traffic stop took a bit of a turn. What I mean by that is that I started witnessing some anomalies, some unusual indications. I started seeing one, two, then several more, and I saw what I would call a cluster of cues. That to me take that baseline normality for a traffic stop to a higher level, to a point to where I started to suspect possible criminal activity. What I mean by that is that I signaled him to stop initially near the tracks, just over the tracks. And he did not stop right away. He was slow to stop. He proceeded to drive north to the intersection of Ohio and made a right turn into the Y. Which, in and of itself, that happens sometimes. There are some explanations for that. Sometimes people want to get out of a busy roadway. Sometimes, especially at night, they want to be somewhere where it's well lit, whatever the case may be. But he had ample space to stop, and he didn't. So, in and of itself, that's not a huge deal, but it was a flag, okay? When I approached the vehicle, I noticed, as I just noticed when he passed me, that the windows were darkly tinted, so I couldn't see him. So I stopped short of the pillar, much more so than normally, but just for my safety. He had rolled the window down several inches. I politely asked him to lower the window. He had lowered it more, but not completely, to the point where I still couldn't see in the car. I couldn't see him. I couldn't see his hands. That also, to me, is an anomaly. That's unusual behavior. People don't typically do that. So I warned him that if he didn't lower the window down the remaining the way, I was going to ask him to step out, and rather than the window, he let him step out. When he did step out, I reviewed the video. I overheard him say something very lightly to the passenger regarding closing the door, locking the door, rolling with the window. I checked to see if it came over the mic. It didn't. But I heard him say that, and he immediately shut the door, and we walked to the back. That's another cue to me. So again, people typically behave like that. I started to believe that it was possible he was trying to prevent me from seeing into the vehicle, or perhaps smelling something inside the vehicle. That was my first gut instinct. So we're talking at the back of the car. I'm checking for insurance information. He did initially put his hands in his pockets, but he took it out when I asked him to. So I wasn't really concerned about that. I explained to him why. At one point, I took the opportunity to explain to him that, traffic stops are dangerous. When you put your hands in your pockets, I don't know what you have in there. When you're reluctant to roll your window down, I can't see in the car. That's a problem as well. But the conversation proceeded somewhat normally from there. We got his insurance information. And then I asked him about why he had pulled into the Y. There's a daycare there, and there were some people coming and going. And I thought perhaps he pulled there because he was there to pick someone up or drop somebody off. And I asked him that question. And he said, yes, I think. And I said, well, what time did they have me pick up or dropped off? And he paused for a moment. He couldn't give me time. He looked at his watch, and after a few seconds, he said, right now. I thought that was a cue as well. I don't know why he would have known just what time to look, but he chose to look at his watch and say right now. So that gave me some cause to pause as well. So in an effort to do two things, I offered him the ability to have the passenger, because I didn't see a passenger in the front seat because he had spoken to her briefly when he got out. I didn't see the children because they apparently were in the back and because of the two ones I could see. But in an effort to be courteous and let him get the child to the appointment, and also to test whether he was being truthful or not, about having a need to drop a child off or pick a child up, I afforded him the opportunity to have the passenger do that. So he agreed, he walked up to the car, he spoke to the front seat passenger, and he reiterated to the front seat passenger that she was to close the door, and I thought I heard him say the word block the door as well. He also told her to take the bag in. Very likely, again, I checked on to see if I could pick it up on the mic. I couldn't, but I distinctly heard him say something about taking the bag in. And then he walked back, and he in fact told me she was going to take the bag in, and asked me if that was okay, and I didn't have any reason not to let him do that, so I'm like, okay. So I was watching his interaction with her as she got out. She walked to the back. She had a laptop bag on her shoulder. She gets in the back of the car. She's in there for a little bit. At one point, she pulls the child out that she's taking in. She returns the laptop bag, and then she grabs another bag and takes that in. And the whole time she's doing that at the rear of the vehicle, he's laser focused on her. I asked him some intermediate, very basic questions about, do you live on base? And he said no. And then as he would make eye contact with me. He looked briefly in my direction, but again, he turned back towards her and was laser focused, in my estimation, overly concerned with what she was doing at the truck. And I believe that was because if there was contraband in the vehicle, I think he had directed her to put it in the bag and take it with her. That's what I think was going on. I asked him a question. I said, well, what is your current address? And again, he looks in my direction briefly, looks back at the truck and says, wait a minute. So in my estimation, he's having a very difficult time dividing his attention. I don't think any person in the whole situation may have great difficulty with that. I see most people in that situation standing there while their wife or girlfriend takes care of the kids, and they're conversing with the officer, but he can't do that. He's laser focused on her in the truck, and he won't look at me, and he's unable to divide his attention. So for all those reasons, in total, I saw like 7 or 8 indicators that told me I saw anomalies. And based upon my training experience, particularly training experience in criminal interdiction, I look for anomalies. Not just 1 or 2 or 3, but I look for what's called clusters. If I see 1 indication, 2 indications, not overly a big deal, but if I start seeing 4 or 5, 6 indications, then that tells me that something unusual is going on that I should investigate further. And I had entertained the idea of running the dog on the vehicle because I truly believed that it was very likely that there might be contraband in the vehicle. But at the same time, based upon his communication to the passenger, and based upon my observance of her taking a bag in, I concluded that if there was contraband in the vehicle, it probably went in with her in the bag. If my dog ran the vehicle, he would scratch it, and I wasn't very confident I was going to find anything in the truck at that point. And then I thought, I'm going to have a guy whose vehicle scratched. I didn't find anything. That's going to be a problem. So I looked at I resorted to the idea that I was going to get you in the car. So that's a long-winded explanation, but yes, I did see some unusual things.
Okay. Do you remember at any point did you shout or yell at Mr. Hurton while he was inside his vehicle?
No, I did not.
Do you remember asking him for his current address?
I did.
Can you explain that situation for me a little bit further, that interaction a little bit more?
That happened, as I indicated just previously, when he was interacting with the female passenger. He had out-of-state plates. They were military plates. And I asked him if he lived on base. He said no. He said no off or something to that effect. So I said, just as a matter of routine, well, what's your current address? And that's when, again, he paused. He couldn't answer me at that point. He waited until she finished getting out of the truck and getting the child out of the truck. He made sure she got the bag. He made sure she locked the doors. And then he reapproached me, and he began to debate whether he needed to give that to me. I explained to him that he did need to give it to me. He wanted to discuss it further, and I reiterated to him that you were required to give me your address. I'm asking you for your address. I'm legally entitled to ask you for your address. He acknowledged that I was legally allowed, but he was confused about whether he legally needed to give it to me. I made some statement to him, I think to the effect of, well, I assure you that you do, or I'm telling you that you do. And then he provided it, and then I proceeded to issue the traffic ticket.
Final question I have: do you have any information showing that a traffic violator must provide a current address during a traffic stop?
I do.
Great.
So I was going to make copies of this for you. I didn't have time.
Sure.
I'm glad to make it for you after the fact.
Sure.
But I have a number of things I'd like to step through here. And I'd like to begin, if I may, you may or may not be in a position to answer this, but in looking at the policy and examining informal inquiries versus formal investigations, I am somewhat curious as to the classification of this particular matter and why it's being handled as a formal investigation, which appears to be reserved for higher levels of misconduct and accusations of criminal behavior.
Well, again, I think it was our hope at one point this would be resolved as an informal. Obviously, Mr. Hurton came in to, file a complaint or make an allegation back on, I believe it was the 16th, the very next day. Sergeant McGuire spoke with him and was unable to, resolve Mr. Hurton's complaint at that point. I ended up talking to myself, and it wasn't able to be resolved to his satisfaction initially. Prior to our most recent conversation, I talked to him on the phone first, and at this point, it was a formal investigation looking into the matter. Again, speaking with Mr. Hurton, I think it was last week, it was Wednesday last week, I believe. After speaking with him, he, questions what information he's obligated to provide. He doesn't, like you said earlier, doesn't dispute what information you can ask for, what he's obligated to provide. So, to satisfy him as far as being to give him a reasonable explanation, that's why we're at the steps we're currently taking.
And I'm not disputing the decision that was made. I guess from my perspective, I see that in my opinion, seems like that goal could have been accomplished informally as well, versus formally. I just have a question about the classification. Another kind of preemptive thing is that I've not seen his complaint. I've not received a copy of the AIC. And I think I'm entitled to that, or should have given that. That helps me. It puts me in a position where I'm better able to evaluate my responses and prepare myself for the investigation. My interpretation of the policy is that, based upon this, that affected employees will be notified of an internal investigation in a timely manner unless such notification would jeopardize the investigation. When employees are notified that they have become the subject of an internal investigation, the police division shall issue a copy of the AIC report, which outlines the allegations. And I just for the record, I didn't receive it.
Well, I was under the impression you had received it. I'd be happy to provide you with that.
If I could get a copy of it afterwards, it's fine.
Sure,
I didn't get it now.
I'd be glad to. Sure.
Okay. So I've got somewhat of a logical progression here. Hopefully, the first matter that I want to present is that I've got a copy of the state statute regarding minor misdemeanor citations. And then citations in general, and I'd like to point out that one of the statutory requirements
Under
is
B?
that, go ahead.
Are you looking under B?
I am. It says the citation shall contain all the following, and I just want to point out that I'm required in the ticket is issued by me is supposed to contain the name and address of the offender.
B1.
Correct. And I would also point out that I believe the purpose of that is so that the court can, in an effective manner, communicate via mail with the offender. And also, if the offender fails to satisfy his obligation to appear in court in a warrants issue, I think the fact that the address affords us an opportunity to look for him in the correct location. And I believe the address he provides is expected to be his current address, not his past address, but where he currently lives. I've got a copy of the citation and release policy here. I'd like to point out on this particular policy, this is our current legislative policy. It mentions minor misdemeanors, and then it also talks about all other misdemeanors. This particular violation was, in fact, a fourth-degree misdemeanor because he's traveling in an excessive speed of 20 or more over. And then in cases of all other misdemeanors, it indicates that I'm paraphrasing it, for brevity, the issues that I may issue a citation with arrest, but there's no requirement that I have to. So I guess my position is that given the fact that he is speeding at an excess of speed and traveling at a fourth-degree misdemeanor, that then becomes an arrestable offense. He could have been taken into custody just based upon that. That's my position. And then we talk about authority to arrest for misdemeanors. This is also a statutory code here. I won't bore you with a long explanation here, but I will present this when I make copies. And basically, this is the Ohio State statutory authority of an officer to arrest for misdemeanor. I won't divulge that anymore. Then I mentioned indicators of activity. I've been to a number of schools over the years, and some of them basic and advanced that specifically deal with criminal and drug interdiction. And I've got a number of cases here I'm going to present where it speaks about indicators and interdiction cues and how they rise to the level of reasonable suspicion and provide a trained investigator the legal ability to further an investigation to the point where reasonable grounds have developed in relation to Ohio State Code 29, 21, and 29, which requires someone to divulge their name, address, and date of birth. My position to you is that aside from the speeding infraction, based upon my observance of these cues and his behaviors, I felt I had reasonable suspicion and reasonable grounds to request that information based upon that alone. I'm not going to bore you with all of this. I do have highlighted sections from each of these, in which I would like to read into the record. If I may?
Sure.
Okay. I'll try to keep it brief. I've only got a few excerpts highlighted. In this particular case, the court indicated that they found Trooper Warner's testimony to be admissible. Trooper Warner's testimony is based upon training he received concerning the types of activities that indicate drug activity. These indicators to a person trained in law enforcement suggest drug activity. Further, Trooper Warner's testimony concerning these indicators was helpful to explain to the jury why Trooper Warner continued to detain and investigate the appellant, Mr. Mitchell, further. Therefore, we conclude that Warner's testimony regarding indicators of criminal activity was properly admitted, and so forth and so on. And that's all I'll point out on that case. These cases are all rather long, so I'm not going to bore you with the bulk of them. This next case is testimony case that was brought before court concerning an arrest by Trooper Sean Smart. Trooper Sean Smart is an instructor in drug interdiction and a current state trooper, and I've been to 2 of his schools, and I've been certified in drug investigation and interdiction by Trooper Smart. In this particular case, Trooper Smart performed a traffic stop and observed indicators that led him to believe criminal activity was afoot, if you will. And I would like to read some of the court's comments into the record concerning that particular stop. And unfortunately, this is probably going to be the longer of what I have to show you, so if you would just bear with me here. The court indicated in the case at hand, the appellant first contends that defense counsel was deficient and failed to provide the testimony from Trooper Smart. Specifically, the appellant asserts that Trooper Smart gave numerous inadmissible opinions about the powdered soap used on the spare tire. The MapQuest directions found in the caliber vehicle. The significance of the written blessing, the candle, and religious tattoos on the bearer's arm. And there are a number of indicators they go into. I won't list all of them. Evidence Rule 701 indicates that the witness is not testifying as an expert. The witness's testimony in the form of opinions or inferences is limited to those opinions or inferences which are rationally based on the perception of the witness and helpful to the clear understanding of the witness's testimony. Trooper Smart testified that he was trained in drug interdiction, attended national level conferences, etc., etc. Has personally trained over 15,000 officers in the United States, including me, and 8 foreign countries on the subject of drug interdiction, and has learned a great deal about the methods used to transport drugs across the country, etc., etc. I'm going to try to limit the scope here, so we're not overdoing this. Trooper Smart went on to testify that in his opinion, the appellant's story that he and Rivera were traveling from California to New Jersey did not meet Rivera's relatives. To meet Rivera's relatives was an unbelievable story. Trooper Smart also stated that in his experience, one would pack a great deal more luggage than the small suitcase provided. Thus, Trooper Smart surmised that the size of the luggage indicated a possible rapid turnaround, etc., etc. Trooper Smart also testified that he conducted a chemical narcotics investigation kit on the white powdered substance, etc., etc. Trooper Smart demonstrated his knowledge of his stated opinions in this case. He also stated a rational basis for his conclusions by providing details of both his perceptions of the events occurring at the traffic stop, coupled with his own experience of drug trafficking and drug couriers, etc., etc. And he referenced a case here. When testifying as to his opinions, Trooper Smart merely described the evidence he observed and how he interpreted that evidence as a lay witness with significant experience. Thus, as the admission of this testimony was not plain error, the appellant has failed to demonstrate that defense counsel's conduct fell below the range of professional assistance necessary to warrant a reversal on the conviction. Moving to the next document I'll present, I actually have this copy of 29, 21, 29. Failure to disclose personal information, and I'll just highlight into the record these points. No person who is in a public place shall refuse to disclose the person's name, address, or date of birth when requested by a law enforcement officer who reasonably believes the suspect is doing any of the following. The person is committing, has committed, or is about to commit a criminal offense. Whoever violates this section is guilty of failure to disclose one's personal information, which is a misdemeanor of the 4th degree. I've got some more highlights on that particular section to share with you in a moment, but I also have located some information regarding traffic offenses, infractions versus criminal offenses. I could find no specific case law reference to determination of when a traffic infraction becomes a criminal offense. It appears that in Ohio that particular matter has not been broached to a point where there's a record of it. However, I did seek out some assistance from some references online. One of those is the Garfield Heights Municipal Court. Garfield Heights publishes and produces, for lack of a better term, cheat sheets for municipal courts in the state of Ohio in regards to the U.S. and NOEL and OVI Commission. We actually use their cheat sheet here. It's a guide that our court uses. And according to the Garfield Heights Municipal Court, traffic offenses in Ohio are criminal offenses. Like other offenses, traffic violations follow criminal procedure. And it goes on, but I'll submit that here in a moment. I have another excerpt from an actual defense attorney's website, an Ohio attorney, and I'll highlight some of the comments here. Traffic citations can be infractions which are not criminal offenses, etc. In Ohio, most moving traffic violations are minor misdemeanors that do not carry any jail time. If you have the same moving violation in 1 year, though, it can become a more serious misdemeanor with greater penalties. And then lastly at the bottom, an enhanced offense includes such moving violations as improper backing, improper passing, and turning violations, or too many speeding tickets in Ohio in 1 year, which can also build jail time. I'll expand on this in a moment, but my contention is that this particular violation, because it was a 4th degree misdemeanor which carries jail time, is in fact properly classified as a criminal offense. And as such, he has to disclose his address per law, per 29/21/29. Another attorney's website, again this is a defense attorney's website, where it talks about criminal traffic offenses. And I'll read just a highlighted portions. A traffic offense is traffic offense is generally considered a crime if it's punishable by imprisonment. And then further down, while some traffic offenses are crimes regardless of the circumstances, some offenses that would normally be classified as mere traffic infractions are elevated to criminal offenses if certain aggravated factors are present. For example, some jurisdictions, including Fairborn, classify speeding as a misdemeanor if the motorist exceeds the posted speed limit by an excessive amount, as is the case in this particular matter. I have a case here where a court has ruled that a Cleveland Metro Parks officer who was issuing a person on a jet ski a minor misdemeanor citation for improper use after certain hours was entitled to that person's identifying information under 29/21/29, and they ruled on that. And then I have a number of cases here to talk about reasonable suspicion. 29/21/29A states that if I have reasonable grounds to believe that a person is committing a criminal offense, I can demand his name, date of birth, and address. And so you get into what is reasonable grounds. There are a number of court cases here to indicate reasonable grounds is not probable cause. I don't have to have probable cause to arrest someone. I just have reasonable or capable suspicion. So I have a number of cases here which highlight that reasonable suspicion requires or enables me to require an address. And I'll read some highlights from some of these, and these are relatively short. The cases are long, the highlights are relatively short. The court in this particular case indicated that section 2921.29A of the Ohio Revised Code provides that no person who is in a public place shall refuse to disclose the person's name, address, or date of birth when requested by law enforcement who reasonably suspects the person is committing, has committed, or is about to commit a criminal offense. Given that Officer Grillin had reasonable suspicion, which is highlighted, to stop Mr. Robertson, that Mr. Robertson's appearance and statements gave Officer Grillin additional facts to support his suspicion, and that the stop occurred in a public place, Officer Grillin was within the authority granted to him by 2921.29A to request Mr. Roberson's identifying information under 29-21-29. Another similar case that is mutually supportive of the same position. In this particular case, again, the case is long, the highlighted portion is relatively short. The court stated in that opinion that the Fourth Amendment does not require an officer to shrug his shoulders at suspected criminal activity where he lacks the precise level of information necessary to perform a probable cause arrest. There's a case mentioned here. The Terry stop allows the officer to briefly stop the suspicious person and make reasonable inquiries aimed at confirming or dispelling his suspicions. In a consensual encounter with a citizen, which includes a conversation initiated by an officer with a mere hunch, an officer can ask for identification. However, where there is reasonable suspicion, a refusal to give a name and address is an offense in and of itself. And then I think lastly, another reasonable grounds mutually supportive case. The court made several comments which I've highlighted, and then we're going to be brief and try to get just the most pertinent here. 2921.29A1. This section of the Ohio Revised Code states that no person who is in a public place shall refuse to disclose the person's name, address, or date of birth when requested by a law enforcement officer who reasonably suspects the person is committing, has committed, or is about to commit a criminal offense. The statute appears to be a condition of Terry v. Ohio. In Terry, it was explained that an investigatory stop, also known as a Terry stop, is proper when the facts demonstrate that the officer possessed a reasonable suspicion which in conjunction with rational inferences warrant the belief that criminal behavior is occurring or is imminent. And I'll not read the rest of it. So I guess basically my position is that it was appropriate and proper for me to require his address, and I think the suggestion to him that he could be and would be taken into custody if he refused is supported by a number of things. Firstly, this was a fourth-degree misdemeanor, not a minor misdemeanor. Having said that, it was a criminal offense, and I'm allowed to request that information under 2921.29A. Additionally, I had ample, based on my training experience, reasonable articulable suspicion to further this investigation because I suspected that he was about to be, was, or would be committing criminal activity. And as such, I also am entitled to his name, address, and date of birth. And he could have been arrested if he didn't provide it. Finally, he wasn't arrested. I provided him with his options. I told him what the option would be, and he reluctantly gave his address. And I proceeded to issue a traffic ticket. As it turns out, he wasn't taken into custody. But for all of these reasons, not the least of which is that the court seemed to indicate that when a criminal offense is present, this information can be requested. If his assertion is that his traffic ticket did not rise at that level, I would suggest that the courts indicate that because this particular traffic offense rises to a level of an arrestable offense where jail time could be imposed, he's required to provide that information.
Okay. And I'll get copies of all those.
I will make copies.
I will make sure I get you a copy of that today, the ASC complaint. I was under the impression you already had that, to be honest with you. So okay. Do you have anything further?
No.
Okay.